In a case related to the FBI's decision to not recommend indictment on the subject of Hillary Clinton and her private email server, a court just ruled that federal officials may not use private email accounts to get around private records laws. Now, this is the U.S. Court of Appeals for the D.C. Circuit. They recently overturned a lower court decision in which judges dismissed claims from the Competitive Enterprise Institute. Now, that is a conservative think tank that attempted to obtain correspondence from a top White House official through a Freedom of Information Act. And of course, the Freedom of Information Act basically says that you can get public records if you ask for them from politicians. Now, normally it's used as a tool to hold our politicians accountable. Now, sometimes Republicans like to use it as a witch hunting tool as well, wasting time and money. Now, in this case, that might have been the issue, but the ruling, I think, is the most important, and I want to go to that. But first, some details. Now, this is the Hill reporting. The White House's Office of Science and Technology Policy said it did not need to search for or turn over records held by the head of the OSTP on a private email account as part of the open records requests. In addition to official White House email, John Holdren, the director of OSTP, also sent and received emails from a domain at the Woods Hole Research Center. Throughout the case, they argued that documents on a non-governmental email server are outside the possession or control of federal agencies and thus beyond the scope of a FOIA request. Now, Judge David Santel disagreed with that reasoning, and he's the chief judge of the U.S. Court of Appeals for the D.C. Circuit, said, no, I disagree. I'm going to send it back to the lower court to re-examine the case. He says, quote, if a department head can deprive the citizens of their right to know what his department is up to by the simple expedient of maintaining his department emails on an account in another domain, that purpose is hardly served. It would make as much sense to say the department head could deprive requesters of hard copy documents by leaving them in a file at his daughter's house and then claiming that they are under her control. Now, that right there is probably one of the best analogies on this that illustrates the absurdity of the government's position of what they're arguing from. Well, since that private email is not government email, the government doesn't own it, even though you get government emails going through it. Well, wait a minute. If there's government emails going through it and you work for the government, yeah, the government kind of has a right, and by government I mean you and me, to know what they're up to know what's going through that if we request it. If we think something's going wrong and we launch a FOIA request, we should have the right to do so. It's a perfect analogy. So, basically, look, I'm all for transparency, right? If you're a government official, you just can't create a private server in order to hide your emails from FOIA requests. And I know that has to do with Hillary Clinton. You also can't create a private email address to hide your government emails from FOIA requests. And look, it's ridiculous, right? And it ties into Hillary Clinton's emails simply because she wanted a private server, partly in order to hide her personal emails. Look, that's fine. I don't want to know what's in her private emails, right? Or personal emails. But the work emails, that's what's important. And they should be accessible upon request, as long as it doesn't endanger national security. We just want to know what you're up to, what you're talking about, as long as it's, as I said, doesn't impact national security. Now, I'm sure this conservative think tank was doing what they normally do and just looking for bullshit. But if this ruling is finalized, and right now it's been remanded for further proceeding, it would ultimately be a good thing in the end. And why? That's because it's about accountability. If there's a government email service that is secure, you should probably use it. There's no reason not to unless you want to hide private things. Don't use your private email. If you're concerned about, hey, the government wants to, read my email, because, I've got my private email is my work email, and you're concerned about the government reading it, well, then maybe you should use a separate government email for your official government business. That way, you wouldn't have to hide your private emails. But look, There's no reason not to use a government email. It doesn't matter if it's easier. It doesn't matter if it's more convenient to you. That is not the issue at hand. The issue is security, and that's what matters. And of course, accountability to the people. Look, in avoiding FOIA requests is kind of the antithesis of being accountable and transparent. And just as a side note here, to kind of end this segment, right now, the NSA can read all of our metadata and essentially our emails. Shouldn't we be able to read theirs upon request? I mean, after all, fair is fair, right?